now this person will have to deal with the consequences of the financial burden in taking care of a child that may have multiple disabilities and not have any say in decision making on if that child should even be carried to term.
Order in the court. Welcome to Queen City News Plus. I'm Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Khalif, always good to talk to you, especially, but this is a really complicated legal issue and a very heart-wrenching legal issue when we're talking about a woman who had a medical emergency but was pregnant at the time, and now they're keeping her alive because of the strict abortion laws in Georgia right now. And she has had her medical emergency back in February, but they want to keep the baby alive until that baby is going to be able to be hopefully sustain life.
After Roe v. Wade, Brian, the floodgates were 1,000% open, right? I mean, you can anticipate that this was going to happen. You didn't have to be a legal scholar. You knew that once this went back to the states, that we would at least have 48 different scenarios happening across the country. And what happened? We now have 48 plus different scenarios happening across the country. Yeah, there's clusters in the Southeast. There's a couple clusters around all the country. But for the most part, it is, choose your adventure, pick your decision on where you want to live, because basically, if you want to make a determination for your right to life or your right to decide to have an abortion, it depends on the state that you're living in. So Georgia has probably one of the most extreme abortion laws in the country. You have these extreme abortion laws. That's the heartbeat law in Georgia, which says if they can indicate the heartbeat, then you can't get an abortion in any scenario, right? Not even for the life of the mother. None of those things are available in that scenario. So how do we get in this situation? You have this lady, she's a nurse, having these extremely major headaches, goes to the hospital, recognizing that she's having a serious condition, or there's blood clots in the brain and other places of the body, and then she's now in a coma, moves from a coma to being brain dead. So she's pregnant. That's a really, really hard situation to deal with. And so the family, and then when I've looked at all the reports that their mothers talked about, the family is saying, well, we want to make a determination on how we move forward with our daughter, with my daughter.
But it seems like it's out of their hands right now.
Well, listening to the state representative, I read what he said earlier, which is, I think it's working exactly how we intended it, even though he understood and acknowledged that this is an unfortunate situation, that he believed that this child should now be taken, be the mother should, the doctors and the folks that are involved in this case are doing what the law requires, and that now the family, he says, will have a determination, that will have the choice to make. Either they can put the child up for adoption or take care of the child. And it's like, well, the parents are saying, well, before we even get to that point, what about making a determination on if we want to allow my daughter to sit on life support, a ventilator, throughout this whole time? Remember, she went into the hospital when she was only 9 weeks pregnant. In some states, that clearly would have been enough time to get an abortion if that would have been the family's choice. And so if this woman that's now going to that has already passed away and is brain dead, that won't be able to come back from this scenario, now looking at the facts for the child already has swelling, liquid and fluids on the brain. They're saying that this child may not be able to even be able to walk or be born living. So now you're going to say that this family will have to wait, from 9 weeks to the 38 weeks they would take her to carry this baby to term. They'll have to wait that time to see if this child will be able to live after the fact. Those are the things where, even if you're on one side or the other, the family is saying at least we should be able to have a discussion, a conversation to figure out what we as a family want to do with this child and with my child, the one that's carrying the baby. And the state of Georgia is saying, no, in this situation, you don't have any say. You won't have a choice. You'll have to comply with what the law says. And here, the law says that that the doctors have no choice, because this would be contributing towards an abortion. If they take her off the ventilator, the baby's going to die. And so their hands are tied. They can't do anything else except for keep her on the ventilator. But then the question that the family's asking, well, who pays for this?
You're right.
And right now, what we figured out is that the family's on the hook for this. So you have a family that's saying, we don't want this to continue and go forward. But yet you're going to say that the family will be on the hook for paying for the medical costs for keeping her on the ventilator for the next 6 months.
Yeah, and Emory University doctors are doing the best that they can under the way the law is written right now. But also, you talk about this too from the case point from where when you talk about this in law school. This is one of those cases where you have to sit there because it is so complicated, because of the letter of the law, but then also the passion or also the compassion that you have for the family involved.
I mean, in law school, you look at this from a couple perspectives, Brian. You look at it from a implementation of the law, and so you want to look at the legislative history. Con law teaches you that. Well, what did they think when they were in the room, when they were talking about implementing this law? What were the discussions? And so you would pull up, the legislative history. You'd see what the senators, the state reps, and the state senators in that state in Georgia were discussing. What was the rationale? What were they wanting to stop? What were they attempting to have happen? And then if that was something that they were intending to have happen, where a person that was brain dead would have to carry to term the life of the child, then you would say that it landed in the situation that they were intending. But also, you would also have a discussion about secondary effects. When you implement a law like this, you're trying to contemplate and think about what other individuals will this law impact. It won't just impact the person having the child or the child himself, but it also will impact the family. In this situation, the grandmother, the mother of the woman that passed away, but the grandmother of now this unborn child. Now, this person will have to deal with the consequences of the financial burden in taking care of a child that may have multiple disabilities and not have any say in decision-making on if that child should even be carried to term. Those are the types of things that I think are secondary effects that clearly wouldn't have been discussed in the legislative intent conversation, because this is a one-off where it's extremely rare and unfortunate situation that now, as you discuss it, is this something that we really wanted to have happen?
Is there anything that the family can do to, because you're sitting there going through this incredibly awful and traumatic type of situation with their daughter that is in a coma right now, where they're waiting on this baby to possibly be born or taken and put into some sort of life support. But do they have any kind of say is through the court system to try to undo or try to rectify a situation in what they would want?
I mean, and so I oftentimes talk about how you need good facts, right? You need great facts to be able to have a claim come before the court and put you in a situation where the court can entertain the constitutionality of a case, right? Take it back to Brown versus Board of Education. Thurgood Marshall and the NAACP were looking for cases that were right before they could come and challenge Plessy v. Ferguson. Well, it's the same situation here. You have a law that's implemented on the state level. Well, for you to be able to challenge it, you'll need standing. You'll need someone that's affected. Well, you have a family here that's affected. They will come and represent the estate of the woman, and they say, hey, this law is unconstitutional and it's affecting us in this way. So now you'll have the court examine this. You'll have them examine the constitutionality of this. And these are the types of cases that you want to be brought to the state level and then ultimately to the Supreme Court level, so they can say, well, is this an infringement on this woman's rights? And is it an infringement on her family's rights via them representing her estate? And if it is, then this is something that maybe we didn't want to give the states the authority to do, or you guys have went too far. The compelling interest for you to try to prevent abortions and limit access to abortion in your state maybe have reached too far, and it overreached it to a person's ability to care and make health care decisions. Oftentimes, too, these types of cases impact and touch on federal law. And so if it impacts and addresses federal law, then sometimes a lawsuit can say, hey, we have a clause here that's being, the supremacy clause is being brought up, where you have federal law that trumps state law, but they're not actually doing what they're supposed to because the state law is being implemented. In this case, I don't think that's the case. I think that this is in compliance with both federal and state law. The only argument here, I think, would be if they're asking for the court to challenge the constitutionality of just the Georgia abortion ban as a whole.
Well, it is a case that we will keep following here on Queen City News, and of course, give you more information, and maybe another time when we have this on Queen City News Plus. Chief Legal Analyst Khalif Rhodes, as always, thanks. Brian Blakely from Queen City News here. If you enjoyed watching this content, be sure to download and watch our full series of Queen City News Plus originals on our app. You can find Queen City News Plus using your streaming devices, including Roku, Amazon Fire Stick, and Apple TV. Just search the name Queen City News Plus. Your support will help us to continue our series. Thanks for watching.